There's a phone call that happened in mid-July that I keep thinking about. A reporter from WSYX in Columbus calls the Southeastern Ohio Regional Jail. Routine request. They want intake footage, the booking video, for the 4 adults arrested in the Siders case. Standard stuff, public record. The jail says, okay, sends over links. Google Drive links, apparently, is how they were sharing it. Days later, the reporter goes back to open those links. Gone. Not access denied. Not this file requires permission. An error message, the kind that says the file could not be found and might have been removed by whoever owns it. Now here's where I have to be really careful because I don't want to overstate what that means. It doesn't say deleted by jail staff. It doesn't say someone got rid of this on purpose. It's a generic Google error. It could mean a lot of things. Technical glitch, expired link, someone reorganizing folders, but the timing is what makes it strange. Because this wasn't the only request that came back empty. WSYX had filed, and I want to be precise here, more than a dozen separate public records requests connected to this case. The family, the government agencies that had contact with them over the years, the property itself, 12+ requests, and one after another, they hit a wall. Some were denied outright. Some just never got answered the way you'd expect. And the station never got a clear explanation for why certain records came through and others didn't, even though, as far as anyone could tell, they were all covered by the exact same court order. That inconsistency is the part that bothers me most, honestly. Not the video itself, the pattern. So let's back up, because to understand why this is happening, you have to understand what's been layered on top of this case since the arrests. 16 children were removed from a home in Hamden, Ohio on June 30th. 4 adults, Gary Siders Jr., his wife Elizabeth, his parents Gary Sr. and Christina, were each charged with 16 counts of felony child endangering. All 4 have pleaded not guilty. That matters. I'm going to keep coming back to that because it's easy to forget in a case this disturbing. Every one of them, right now, today, is legally presumed innocent. Nothing in this video changes that. Nothing in the court record changes that yet either. What happened almost immediately afterward is where this gets complicated. Attorney General Andy Wilson called what investigators found pure evil. The county sheriff, Ryan Kane, said something like, and I'm paraphrasing slightly, that livestock get treated better. Strong language. Understandable, honestly, if you've read anything about the conditions described in the filings. But strong language from officials in a case this public creates a problem for defense attorneys. And Gary Jr.'s attorney used exactly that problem to ask for something significant. A gag order, July 14th. The judge, Lena Featherolf Rogers, grants it. The reasoning, basically, is that comments like pure evil could poison the jury pool before anyone's even been formally tried. Can't seat an impartial jury if half the county's already decided the outcome based on a press conference. That's the legal logic, and on paper it's not unusual. Judges do this in high-profile cases, but then 9 days later, a second one. July 23rd. This one covers Christina's case specifically, and it's broader. It restricts the defendants themselves now, not just officials. It reaches investigators, experts, support staff, court personnel, basically everyone connected to the proceeding, discussing the merits, facts, evidence, materials in discovery. Off limits. There's one detail in there worth sitting on for a second, because people miss it. The order does not ban discussion of information that's already part of the public record. That's actually a meaningful carve-out. In theory, that means basic facts. Arrest dates, charges, court filings that have already been submitted should still be accessible. Should be. Which brings us back to those 12+ requests that kept coming back empty. Because if the gag order technically allows public record material to stay public, then why is a reporter getting error messages instead of answers? I don't think there's a clean answer to that yet. I want to be honest about that. But someone with real legal standing started asking the same question, and that's where this stops feeling like just a communications hiccup. Ron O'Brien spent close to a quarter century as Franklin County's prosecuting attorney. Before that, Columbus City attorney. This isn't some outside commentator with a theory. This is a man who spent his career issuing and defending these exact kinds of court orders. When he looked at the gag order in this case, he didn't hedge. Here's what he said, and I want to give you his exact words, because paraphrasing this would lose something. You have to present evidence, and the court has to make some very specific findings that justify it. And none of that was done in this case. Sit with that for a second. He's not saying the order was a bad idea. He's saying, as someone who knows the procedure inside and out, that the procedure wasn't followed. He went further. He said, "It appears on the face of the order that the rules weren't followed in issuing the gag order." And then this part, which I think is the most pointed line in the whole thing. If they're concerned about public statements, I have not seen or heard public statements that any side should have a concern about since the day of the arrest. Meaning, after the initial press conference, he's not aware of anything inflammatory enough to justify locking the case down this hard. Now, to be fair, and I do want to be fair here, a sitting judge presumably has access to filings, arguments, context that a former prosecutor watching from outside doesn't have. It's possible there's something in the record justifying this that hasn't become public. That's a real possibility. I'm not going to pretend it isn't. But O'Brien's critique is on the record, publicly, from someone with actual authority to make it. And it wasn't the only pushback. The Columbus Dispatch didn't just complain. They filed an actual lawsuit with the Ohio Supreme Court, challenging the order directly. Their attorney, Jack Greiner, put it plainly. The paper is, in his words, protecting the public's right to know what is happening in this horrific situation. And here's something I didn't fully realize until I dug into this more. It's not just the Dispatch. Multiple lawsuits have now been filed challenging this gag order, plural, from different directions. So you've got a former career prosecutor saying the process looks broken. You've got a major newspaper suing a state Supreme Court over it. You've got a second, wider gag order stacked on top of the first one. And in the middle of all that, a local TV station is watching its evidence requests either get denied or just vanish. I keep asking myself what connects all of this. And I don't think it's some grand conspiracy, if I'm being honest with you. I think, and this is just me thinking out loud here, I think what you're watching is a system that got hit with way more scrutiny than it was built to handle, all at once, and it's cracking in visible ways. Because remember, this is rural Vinton County, small courthouse, small sheriff's department, relative to the size of what landed on their desk. And within days, this went from a local case to something the entire country was watching. True crime channels, national news, internet sleuths combing through every filing they could find. That kind of pressure does something to institutions that aren't built for it. Sometimes it makes them defensive, sometimes it makes them sloppy, sometimes both at once. I'm not saying that excuses anything. I'm just saying it's a more honest explanation than cover-up, and honestly, a more unsettling one in its own way. Because a cover-up implies someone's in control. What this looks like, at least from where I'm sitting, is closer to a system that isn't. There's another thread running underneath all of this that I think connects back to the transparency fight, even though on the surface it looks unrelated. All 4 defendants have now, in some form, requested competency evaluations. Gary Jr., approved. Christina, approved, same day, July 29th. Gary Sr., approved earlier, and he was actually released from custody due to serious health issues while that process continues. And then Elizabeth. She was the last one. Her attorney filed August 4th, and this is important. As of that filing, the court had not yet ruled on it. Her request goes a step further than the others, too. It's not just, is she competent to stand trial? It's a 2-part motion. If she's found competent, the attorney is also asking for a separate evaluation into whether she could be found not guilty by reason of insanity, meaning whether she was capable of understanding that what was happening was wrong. At the time, it was happening. I want to slow down on this because it's easy to hear insanity defense and picture something dramatic from a courtroom movie. That's not really what's being requested here. Competency and insanity are 2 completely separate legal questions. Competency asks, can you understand these proceedings right now, today, and help your own attorney defend you? Insanity asks something different. At the time of the alleged offense, because of a mental illness or defect, could you understand that what you were doing was wrong? One doesn't determine the other. You can be mentally ill and still be found competent. You can be competent and still have had, at the time, a condition that meets the legal bar for insanity. They're separate lanes entirely. And this is where I have to be really careful because I think this is where a lot of coverage, mine included in earlier videos, has leaned too hard into speculation. I don't know what's in these evaluations. Nobody outside the court and the medical examiners does yet. The defense attorney has said, in filings, that his observations during meetings with his client raised concerns. That's his professional assessment, stated for the purpose of requesting an evaluation. It is not a diagnosis. It's not proof of anything. It's the first step in a process that's specifically designed to find out whether those concerns are accurate. So why am I bringing this up in a video about missing files and gag orders? Because I think they're connected in a way that matters. You have a legal process trying to work through incredibly serious questions about 4 separate people, 4 separate levels of potential responsibility, and possibly questions about their mental state going back years. That process needs time. It needs quiet. Courts genuinely do worry about pretrial publicity contaminating a jury pool in cases like this. And at the exact same time, you have a public, a genuinely horrified public, that watched 16 children get pulled out of conditions officials themselves called almost unimaginable. And that public wants information, not gossip. Information about how something like this could go unnoticed for years, about whether state agencies missed warning signs, about whether the systems meant to protect children actually worked at any point for almost 2 decades. Those 2 needs, a fair process and public accountability, are in direct tension right now in Vinton County, and I don't think there's an easy way to resolve that tension. I really don't. What I do think is worth paying attention to is who's caught in the middle of it. The 16 children are in state custody now, receiving medical and psychological care. Several were hospitalized when they were first found. That part isn't in dispute. It's been confirmed by multiple officials, multiple filings. What isn't being made public, appropriately I'd argue, is anything more specific about them individually. Their care, their identities, their day-to-day reality right now. That should stay private. That's not where accountability needs to be pointed. Where it needs to be pointed, I think, is at the systems around this. The truancy reports that got closed instead of followed up on. The lack of medical records across almost 2 decades. The way this family reportedly moved through multiple counties and at least 1 other property without triggering the kind of oversight you'd hope would exist. And now, the way public records requests connected to accountability are getting denied or disappearing without a clear explanation from the agency holding them. I don't have a neat conclusion for you tonight. I wish I did. Usually these videos end with some kind of resolution, or at least a clear next step to watch for. This one doesn't have that yet. What I can tell you is what's actually pending right now, verified, on the record. The Ohio Supreme Court has an active lawsuit in front of it from the Columbus Dispatch, challenging whether this gag order was properly issued in the first place. That's not resolved. Multiple other legal challenges are apparently also in motion. Elizabeth's competency and insanity evaluation request is sitting in front of Judge Rogers, unresolved as of the most recent filing. The other 3 evaluations are moving forward, with results expected to come back to the court within the time frame the judge set, and somewhere in a jail server or a Google Drive folder, or wherever these records actually lived, there's still an unanswered question about why a video that was supposedly available for public access simply stopped being available. Maybe it's nothing. Maybe it really was just a broken link, a technical error, an owner who reorganized a folder without thinking about who still needed access to it. Or maybe, and I say this as a possibility, not a conclusion, maybe the pressure this case put on a small county government created exactly the kind of confusion where things get lost, or restricted, or handled inconsistently without anyone sitting in a room deciding to hide anything at all. I think that's actually the more likely explanation, if I had to guess. Not a conspiracy. Institutional strain. But I understand why, from the outside, those 2 things can look almost identical. What I do know is this. A former prosecutor with decades of experience looked at how this was handled and said, publicly, that the rules weren't followed. A major newspaper thought it was serious enough to take to the state's highest court. And a reporter trying to do her job kept hitting doors that used to be open. That's not speculation. That's just what's on the record. Right now, in a case that's still very much unfolding. I'll be watching the Supreme Court filing. I'll be watching whether Elizabeth's evaluation gets approved, and I'll be watching whether the state ever gives a straight answer about that missing footage. If something changes, You'll hear about it here, the moment it's actually confirmed, not before.